Get started. For the record, we're now being recorded. I don't know if you guys hear that announcement when that happens. I'm going to start out with the introduction, and then I want to have a little bit of back and forth about just confirmation of the process that I'm going to spell out here. We had talked about doing the kind of more like the land use process. I think there's maybe the Bend has a few of the people providing testimony, and it sounds like maybe the applicant requester might also. Okay, so we'll get started. It is now 10:01, September 20th, 2023. This is a meeting of the hearings officer for DLCD on an enforcement proceeding against the city of Bend. My name is Ann Davies. I'm the hearings officer for this morning's hearings. Pursuant to Oregon administrative rule, the Department of Land Conservation and Development has contracted with my employer, the Lane Council of Governments, to provide these hearings officer services. So there's one hearing on the agenda this morning. It involves the petition of BCL LLC for an enforcement order against the city of Bend pursuant to ORS 197.324. Briefly, the petition seeks a determination that the city of Bend's approval standards, special conditions on approval of specific development proposals, or procedures for approval do not comply with ORS 197.307 subsection 4, which is the requirement that certain standards and conditions related to approval for needed housing be clear and objective. In July, the commission determined there was good cause to proceed in this contested case hearing. Notice of this contested case hearing was provided to the parties pursuant to administrative rule. The notice provided directions on how persons could request party status. Other than the city of Bend and the petitioner, BCL LLC, no person filed a petition requesting party status or limited party status by the deadline set forth in that notice. Accordingly, the parties in this matter are limited to the petitioner, BCL LLC, and the respondent, city of Bend. Prior to this contested case hearing, the parties attempted to narrow the issues by determining the scope of the hearings officers and commission's authority over the issues raised by the petitioner requester. We had some briefing on that issue, and then a ruling went out. The notice of the contested case hearing identified the following issues to be considered as the threshold issues. And I'm just going to read the issues identified in the notice of contested case hearing. What types and categories of city actions fall under the authority of the commission to issue an enforcement order under ORS 197.320 subsection 10? And should this enforcement matter be considered as a general review of the city's programmatic compliance with ORS 197.307, or should it also include a comprehensive review of whether the specific land use applications cited by the requester comply with ORS 197.307? So I issued rulings on both of those. The second one, I think, is pretty much a final ruling. The ruling on the first threshold issue was not complete. So I'm allowing the parties to continue to make arguments on that. I understand that the requester has an argument that the threshold issues are done and we can't re-argue those, and that's fine. You can make that argument and I'll consider that. The specific issues identified in the notice are the following. One, misaligned timelines of planning and engineering reviews resulting in tentative plat expirations. 2, unreasonable delay in reviewing and approving engineering plans for required public improvements. 3, requirement to extinguish private easements prior to public dedication. Parties have the right to respond to all issues properly to the hearings officer and to present evidence and witnesses on those issues. 4, arbitrary fees. 5, unreasonable delay created by review of condominium plats. 6, unreasonable cost and delay caused by the city engineering department's underground injection control, or UIC, policy for stormwater facilities. The notice of contested case hearing in this matter anticipated that no witnesses would be called. I'm not going to refuse to allow testimony by either Mr. Kine or the staff for the city. So the procedure, I don't know, Howard, if you were planning on giving a short staff report. But my proposed process is that DLCD will give a short staff report to the extent they want to. Then we'll hear from the requester petitioner. And assuming there's no one online, I don't think there's anyone online who isn't related to the requester or the city of Bend. And then we'll have the city response to petitioners' arguments. If DLCD wants to comment at that point, they can, but it sounds like maybe Gordon's going to be gone by then. And then we'll have final rebuttal by petitioner. Does that sound consistent with kind of what everyone was thinking, how we would proceed?
From the requester standpoint, that's what you explained before, kind of like a land use proceeding. So we understand that and agree.
Okay. How about the city?
Yeah, thank you. It does. I will say that, I mean, I appreciate the hearings officer's openness to allowing relevant information in. We didn't come today prepared to offer testimony from either Mr. Grayson or Mr. Stevens. Mr. Stevens has signed a couple of declarations. I think, you know, depending on how this goes, I may look to them, but it sounds like this is a fairly open-ended proceeding, and that's fine. But I don't necessarily anticipate swearing anybody in.
Right. So part of the reason I kind of put that out there is that after reviewing all the materials, I anticipated there could be a time when I might want to ask a evidentiary type question, and I was anticipating that may not be completely appropriate for the city's attorney as opposed to the person who actually has that factual information to respond. So
yeah, I think if it's helpful, I think we at least would welcome questions you have of the subject matter expert folks in the room who are not necessarily me.
Yeah, okay. Sounds good. Then I think so trying to think if there's anything else. Oh, I did receive the materials that were submitted like 5 minutes ago. Both parties submitted additional written testimony. I have not had a chance to review it, so just keep in mind that I have reviewed everything else, and we'll just proceed with that process that I outlined. Okay, so we'll start with a short staff report if Gordon, you want to do that.
Thank you, Hearings Officer Davies. We really do not have a staff report other than to just summarize that clearly where we were is that the commission found good cause to proceed at its July meeting, and we've proceeded to this and directed this contested case hearing, which is being held today. Subsequent to this, once we get a draft order and a determination from you as the hearings officer, we as the staff will, DLCD staff will review it and make a recommendation to our commission, which will hold a hearing at its November meeting in Medford to make a final determination on whether an enforcement order should be issued and what, if so, what the terms of that enforcement order are. And so that's what will happen subsequent to this meeting today. As stated, I need to leave at 10:30, but Angie Brewer, who is the regional representative for Central Oregon, will be here for the entire meeting. If there are any questions of a procedural nature that need to be answered, she will take them on. Casaria Taylor is also our administrative person working on this if there are any questions in her area of expertise. So with that, I would turn it back over to you, Hearings Officer Davies, to conduct the proceedings.
Okay, thanks for that. I did see that someone else came on, Dee Dee Fraley. Is that someone who is related to a party or a DLCD person?
Yeah, I can answer that. Ms. Fraley, she's a member of the city's private development engineering department, not participating or a witness, but I think just observing today.
Perfect. Okay, thanks for that clarification. Okay, so I'll turn it over to the requester / petitioner. I didn't anticipate having any timeline limitations, I'm pretty much free until 3. Can't anticipate that it'll go that long, but we were also joking before the parties got on that maybe it'd be done in half an hour and how Gordon wouldn't miss any of it. So I don't think that's true either. So go ahead. We'll hear from the requester first.
Good morning, Hearings Officer Davies, staff from the LCDC, and my colleagues at the city. I'm Chris Kobach, and I represent the requester, DCL LLC. We have a representative, Larry Kine, who's here, and as Mr. Leiheiser said, if you have questions that I can't answer, Mr. Kine may be available to answer as he lived with this, but we weren't expecting to call witnesses.
Yeah.
And we think personally, I think the timeline is probably going to be closer to the half hour than the 3 o'clock. I think both parties have done an extensive job in writing, and you're able to take that with you, which might be more helpful than trying to remember what we all said. I'm going to focus really during our initial presentation on the rebuttal testimony that unfortunately you haven't had a chance to read. I think both parties probably were scrambling late last night to get the final T's crossed and I's dotted on that. But that's where I'm going to focus. But I first want to kind of put the issues in context a little bit, because there's not a direct correlation, in my opinion, between the areas of concern that staff identified and the petition. It's all there, but some of the areas of concern, in my opinion, overlap with some of the assertions in the petition and consume some of them. And so I wanted to kind of put this into a little bit better context, hopefully. Giving you a background of what an applicant, the requester, sees when they go through the city process. So, this deals with housing, needed housing applications. It doesn't deal with anything else. And so when an applicant in the city of Bend wants to develop housing, needed, affordable, we have both in this case, there's different processes you have to go through. And the first process is the land use approval. And there's a couple. If you're doing a single family house on a single lot, in most cases, I think you're going to have to just go get a building permit. There really isn't a land use process. But anything above that, you usually have to go through some site plan review if you're going to do more than one dwelling on a lot. And that would even include, I think, a duplex. There's a minimum development review that the city requires. And then if you're going to do individual lots, single dwellings on individual lots, then you're carving up a piece of property, and then you have to go through the city's subdivision process, which follows state law consistently. It's a 2-stage process: the tentative plan approval, which is where all the substantive criteria are applied, and you have a public hearing usually, and then the final plat, which is more of the technical. And so the allegations in the petition really get to not the time it takes to get through the land use process. And I say that because there were some graphs that we talk about in our written rebuttal, where the city appears to have been suggesting that, my client, the requester, through either decisions or incompetence, has taken longer to get through the land use process than other people. Well, it's not part of the petition. It's not part of any area of concern. Land use is a discretionary process still, even though ORS 197307 has taken a lot of that out. There is still process and notices and participation from other people and appeal rights. And there are things beyond our control or the city's control that drag land use decisions out. We recognize that, and those charts, in our opinion, are really irrelevant, and they're only put in there to try to make the requester look bad. But what we're focused on really is, once you get that approval, and we've given you examples in our evidence that you've already received, where the city, in their final land use decisions approving housing, they put in these special conditions. You can get up to 40, 50, 60 conditions, but there are a couple that are really critical. Like most local governments that I deal with, and I think probably in your experience you've dealt with, when a developer or applicant comes in and asks for something, the city looks at, well, what can we get back as far as public improvements? If you're going to impact our systems, et cetera, we're going to take SDCs, of course, but we also look to get stuff, improvements, property, etc. So there are routinely, if not in almost every case, a requirement that the applicant provide some public improvements. They have to build them and give them to the city when they're done. And then consistent with ORS 92.097, that allows, if the city's going to make the applicant pay, that statute's really important because it says that the applicant then can use their private engineer to design and inspect those improvements. And then it goes on to say that the city can, it doesn't have to, but it has the right to review and inspect. And it can charge for that if it charges the actual cost of the service. And so there's always a condition in there that requires the approval of plans for those public improvements. So that's another special condition. And then there's another one even that's directly related, which is every approval has a special condition telling the applicant, you have to get all this done within a certain period of time or your approval is void. And that's in all residential, either site plan review or minimum development review or subdivision review. And so from the applicant standpoint, when you're done with the land use approval, you know what you have to submit to satisfy those conditions. They're directly linked to that land use decision. It is, you must satisfy those. And to satisfy them, you have to have your engineer prepare plans. And we've given you in our direct testimony the number in a ballpark on how long it takes a typical subdivision to get their plans prepared. It's like 13 man-hour days, 100 and some hours. And so they prepare them and you have to submit them to the city. It's required. We don't have a choice. And that's where we've alleged that there is this backlog and this delay that's not justified. It's not reasonable. And it is discouraging housing through this delay, because when it takes over a year to get your public improvement permit, that's a year that you have into that expiration period, that duration of approval. And then you have to go through more of the city process to construct the improvements. You have weather issues and bend, there's things that come up. And then you have to go through the inspection process. There can be work that has to be corrected. There's a lot of things that happen. All of that has to happen in that condensed 1 year period, or you face approval. So there's two things. One, we believe a year, averaging a year to simply review engineering plans that took significantly less time to prepare is unreasonable. The city's not, the statute does not, in our opinion, give the city the opportunity to redesign projects. And that's part of our petition and our evidence, is that rather than just look and say, does this meet this objective standard? There's a lot of re-engineering going on that we don't believe is contemplated by the statute, and we don't believe it's consistent with the mandates of ORS 197.307. It should be a simple, objective review. And it should be done quickly with one review. We have evidence that we're going to get into about how multiple reviews are happening, with comments that come in the third review that could have come in the first review. So all of this is what the applicant has to deal with as they're going through this process. And on the building permit side, then in a site plan review, you have to get building permits before, in that 2 year period as well. And we've explained to you our disagreement with how that provision works, because the code says a building permit, but when you're doing 5 or 6 individual structures on one lot, the city's policy, it's not in the code, the policy is you got to get all those permits. So then you have to go through the building permit review, and that's a similar process where your engineers or architects design it to meet the code, and then the city engineers, I don't even know who at the city reviews the building plans. I'm sure they have an architect or somebody with that training, but then they're getting comments back, and that takes a long period of time. So that's really kind of the genesis, and that impacts a lot of the other areas of concern. So I want to bring this together. So for example, we've said one of the allegations of our petition is not only does this delay in the review process, the engineering, jeopardize projects from a expiration provision, it slows down the final platting. And so you only have so many years to get a final plat recorded. And what we've alleged, and we believe the facts demonstrate, is that this lag, this backlog in getting these reviews done at the front end put projects in jeopardy of not being able to get their final plat recorded. And under the state law, that plat has to be recorded before you can sell a lot. So that's part of the delay. The other one that's a little more hard to connect is the UIC issue. And I wanted to clarify, we're not really alleging that the city's UIC has a policy that directly violates the statute. What we've tried to demonstrate with that UIC issue is, in that approval, the hearings officer actually said you get to use those. And we had, because it was based on studies that we submitted, that the city has over 5,000 UICs, and they're safe.
And you get to use them within the 500 foot.
Exactly, because if we demonstrate protectiveness, and it gets really scientific. I've learned a lot about this, but I still probably just scratching the surface of the science. But the study that I've read that the city had commissioned demonstrated that if you have 5 feet of vertical separation between the bottom of the UIC and groundwater, that groundwater is protected, even if you assume 10 times the level of contaminants that the consultant expected from a runoff from a street. Because the UICs really, they collect public water from the public street that the applicant builds. And so there are naturally going to be some contaminants that come off of the road because cars drive on it, people do stuff on the streets, and when the water comes, it goes into the UIC. But their study showed that it attenuated to acceptable levels within 5 feet, assuming a 10% concentration, or 10 times the concentration of what you would normally expect. What we tried to use that to demonstrate is, when we submitted the plans on that project, the initial comments came back, and much of it couldn't be reviewed because the city engineers simply ignored that decision and said,
that decision had already been made at that point.
It was final. It was final. It went to Luba. It came back. And
okay, so this UIC thing, I did dig. I mean, I didn't know what UIC was before this matter came to me, but I'm just gonna let you know where I've gone, partly for the city's benefit, so they have something to respond to. I dug into the design standards, and what I'm seeing is basically a requirement. And I think the city, in one of the last responses, the city did say, we're going to look at this and we may decide to change something. So it's 6.3 of part 2 of the City of Bend design standards, and it talks specifically about the UICs, and it says UIC systems shall not be installed within 500 feet of any water wells within drinking water protection 2-year time travel areas, or in locations where the injected stormwater could affect contaminated soils or DEQ cleanup sites. UIC separation from water wells must be maintained unless a more stringent guideline is imposed by DEQ. So where I'm going is thinking that, if the city's engineers or whoever's reviewing this stuff is looking at this design standard, they're seeing a shall not. And so, in the whole argument about delay, it's definitely going to cause a delay if they're looking at something that is completely inconsistent with what this hearings official has just said. So it seems like a simple fix would be to change that language in the design standards to be consistent with what the hearings officer required. And so that's where I'm going. I'm not sure. I don't know if the city's going to argue that I can't go that far. I don't have the authority to do that. But that seems like, apart from that jurisdictional issue, that seems like a pretty easy fix to avoid delay based on misreading of that.
No, I appreciate that comment, and I'm sure we'll hear from the city on that. And what was in the record, and I think we put it in this record too, is there's even a little bit more inconsistency, because the DEQ permit that the city got, the study that the city submitted that said UICs are okay within 5, if there's this 5-foot vertical separation, that was used to get their DEQ permit in 2013. And the conditions on that DEQ permit specifically say new UICs can be used, but they have to be designed with that level of protectiveness. So there does appear to be a disconnect of some sort between some things in the city documents and their own DEQ wastewater permit. And maybe this is an opportunity for the city to go back and kind of reconcile all of this because they have UICs over 5,000. So we know based on that in their study, they can be used safely. Maybe there's a way to figure out how to put a little bit more concrete parameters out about when they can be used and when they cannot be used. But in our case, we submitted all that evidence and the hearings officer said, yeah, the permit allows it, the study allows it. You've got a certificate from an engineer saying you meet this protectiveness, they're good. And the point we were making is we had to, and we got through the issue. The city's going to point out that we got through the issue. We did. But I had to get involved. We had to take time. We had to take money, and we had to deal with something that, in our opinion, we should not have had to deal with. We do sincerely believe that was unreasonable and unnecessary cost and delay that we should not have had to incur on a needed housing project to deal with this engineering issue. So it's really related to, I guess my point is to the first couple, which is these delays in the review. They involve more than just not getting to the reviews on time. It's how the city reviews them. For example, you ignore a hearings officer's decision. You ignore some comments on the first review and put them on the second and third review. They could have been on the first one. It would have eliminated some reviews. And so that's the delay one. And that subsumes a lot of our allegations. The other one is this easement standard, and we're going to talk about that, this new standard that the city adopted in chapter 3.4200 that says for these housing applications, before you dedicate property, you got to remove all private easements and encumbrances on the property. And we've demonstrated with batch review how the city's position and how they filtered that out to the opponents caused significant delay and a lot of money. We're still in a civil lawsuit over that based on that, how that information was meted out. And that's Exhibit 5 to our written testimony. You'll see what the city engineer said, which was, in our opinion, way out of bounds for that role. But that caused significant delay. And then I've given you an example from another client I've done out in Southeast Bend, where although they weren't subject to it in their tentative plan review, the city imposes that new requirement on the final plat review. So you don't get out of it just because of the goalpost rule. That's the city's position. And so there were old easements that the city said, you got to deal with them. And again, the city's response is, well, you got through it. Well, we did. A lot of delay and a lot of cost, but we got through it. And that's our really kind of one of the things to take away from this is just getting through it. We don't believe is a defense that the city can avail itself to. Getting through it, if getting through it incurs the unreasonable and unnecessary cost and delay, that's what the statute's supposed to get at, not just denials of approval, in our opinion. So I'm going to get to our rebuttal testimony because I think it's really kind of the best evidence you're going to see, because in the city's rebuttal and some of our stuff, we're all citing examples and everybody's pointing fingers. And you'll see in the city's testimony, I think it was really unfortunate that the city, I got an email about a meeting at the city on another project, and it was the meeting with customer. I was like, that's great, we're customers. Well, if you read that testimony from the city where they accuse my client of something dishonesty, a word I've never heard, I guess, reflexive dishonesty, deceit and misrepresentation, as a customer, that's kind of hurtful and alarming, is that when you avail yourself to a legal process and try to address situations that you legitimately believe need to be addressed, you sincerely hold these beliefs and you're trying to get it fixed, and then you're the customer, and then the provider comes back and accuses you of all this stuff instead of saying, okay, here's how we're going to resolve these issues. So that was our first observation of the response to this. Is it's very sad and unfortunate that our provider thinks of its customer the way it thinks of us. But what we did is we kind of looked at their statistics. So in our testimony, we showed 7 examples of other engineering projects that took a long time. So what we were trying to get at is it's just not us. That was the city's position. It's just BCL. They're terrible. Their engineers are terrible. It's all them. These are all self-inflicted woes. And what we tried to present is a snapshot that there are other projects, and we got all that from the city's City View portal. Everything's electronic here, and it's really neat. You can go on, find a property, and you get all the permits, and you can get a lot of information that way. So that's what we started with. And then you saw the city's testimony where they gave you these graphs. Not a lot of detail, but as I said in my rebuttal, since we're here only to talk about needed housing, we assume all of their statistics relate to needed housing projects. Otherwise, the statistics are meaningless and could be really kind of misrepresentative of the facts. And so two of the studies that the city did relate to land use approvals, figure 1 and 2. Again, irrelevant. They're not part of our claim. But starting at 3 and 4, it's kind of telling, because if the city's position is, well, BCL is an outlier, they're responsible for their own problems, and they're the only ones having problems. I was looking at their statistics, and we put this forth in our testimony, and if you go to some of these figures, for example, engineering review, days between the here it is. Figure 3 is good. So there are the number of review cycles for engineering permits. So in their chart, they show, well, there's 3 of those. So they go, these comments come back and forth. I think you're probably figured that out already. Yeah. So the engineer submits something, the city sends it back with comments, and then the private engineer has to respond to them. Then there's more comments, and our position is a lot of those comments should be done on the first one. We shouldn't have so many cycles of review. Well, the city points out that we had 3 applications for housing that had 5 review cycles, and so it's our problem. But their own study shows that there are 11 others that had the same 5. So 11 other needed housing applications had to go through 5 cycles as well. That's not just us. And then 8 cycles, there were 6 others that had to go through 6 cycles, only 1 of ours. So there's another 6 needed housing projects that had to go through 6 review cycles. There were 2 that had to go through 8 review cycles. None of those are ours. So when you carefully go through these statistics, I think they really support the conclusion that this is a systemic issue. It's not just BCL. It's not BCL's engineer. This is every needed housing. Many needed housing applications are seeing the same delays in the engineering review. Total days between permit issuance is another telling one. That's figure 5. So I'm going to focus on the 251 to 300 days. There are 27 other applications that took that long, engineering applications. 1 of ours did. They don't have a 1 there, but I'm pretty sure their graph shows a 1. It is a 1. It's based on what they did elsewhere, showing a 1. I think that bar shows 1 of ours. And then the ones that took over a year, 301 days to 400 days, 29 others, 3 of ours. Again, 29 other needed housing applications took between 301 and 400 days to get engineering that was stamped and approved by a licensed civil engineer, simply reviewed for compliance with what should be clear and objective standards, engineering standards. There were 19 other applications that took 500 days, only 1 of ours. So when the city says, BCL is just bad and it's their problem, I think their own statistics belie that. This, as I said, this is a major problem. Building permit review, their chart on total days between application is on page 5 of Mr. Thomas's first declaration. Same story. Multiple applications take 151 to 200 days to review building permits. 20 some, it's real, I think it's 25 or 26, 0 of ours. The ones between 201 and 250, none of ours. Between 300 and 400, 16 others, it looks like 1 or 2 of ours. So again, this long period of time it takes the city to review critical documents that are required by land use decisions to vest and to get, more importantly, to get this housing out to people who need it. It's not just us, it's everybody. So we did one step further and we went to we did our own study quickly. Sent a study out to an anonymous study to 7 of the bigger engineering firms that do housing applications. We got 5 of them responded. And it was really telling us, the first thing is, they all do residential in the last 3 years. They've all done
So
residential.
these are all engineering firms that work in the Bend area?
Absolutely.
Okay.
On residential project, that was one of the questions. That's in our, all of this stuff is in our stuff we sent in today.
Yeah.
100% of them said, that responded, our average time to get an infrastructure permit through the city engineering review is over 12 months. 100% of them. I think it shows 67% indicated that they go through more than 2 reviews. 67 to 100% in that category said, we get multiple comments that have nothing to do with engineering. They're subjective comments. What's really telling is some of the last studies. So 100% of those responding engineers said it's getting more difficult in Bend rather than better to get through the process. 100% said it's easier in other jurisdictions. 100% said it's more costly now than before in Bend, and more costly than other jurisdictions. That study really tells you why the LCDC should be interested in this, why they are interested, or we wouldn't be here today, and why some action, meaningful action, needs to happen, because this is a problem, as I showed from the city statistics that are going, is widespread, and it isn't getting better. And the housing crisis isn't going away. And so this needed housing has to get done. It has to get on the market. And if the engineers in the city are all in agreement that it is getting more difficult, more costly, more expensive, that is a problem we believe that falls under this commission's jurisdiction, because it is action directly related to a land use decision. These are special conditions of approval in land use decisions, and applicants have to go through that process. They don't have a choice. So that's on the delay. That's really what we wanted to get across. I do want to double back a little bit on the encumbrance issue, because the city had said some stuff that needs a responding. So
Can I stop
Yep.
for a minute and stick with the delay for a bit?
Absolutely.
So the city's response to at least some of those requested actions are that code is usually outward facing. So it's telling the user what to do and not necessarily telling the staff what deadlines they have. So I think one of their responses was, this isn't something that, part of it is a jurisdictional issue, is that I don't have authority to tell them staff, how much staff to hire, or even a deadline. So can you just briefly explain your response to that? Like, if I were to agree with everything that you said, as far as me ordering a particular action for the city to take.
Sure. Well, we gave you a suggestion. We think that it would be within your jurisdiction, in the commission's jurisdiction, to say you have, if you're going to exercise your right under ORS 92.097, which you do not have to do, if you're going to take that right and review these plans, you have to have that process done within 60 days. And it provided you don't get extensions from the applicant. Obviously, that if the applicant says you don't have to do it, you don't have to do it. But if the applicant's moving forward and doing what they have to do, you need to get that done in 60 days. And why we think that's reasonable is a couple things. One is, if you look at where this fits in the process, cities can get land use decisions done in 120 days. They have public notice, public hearings, appeal periods, everything. That's elaborate, and it takes 120 days. So we know that when there is a deadline, cities meet it. This city meets it. Second, we gave you information from some other jurisdictions nearby: Medford, Prineville, Redmond. I think there was one other, but in any event, they all get it done faster. They all get it done within that 60 days approximately. And so if there's a deadline, people figure out how to get it done. And I think that's part of the problem. If there's no deadline, things don't get done. And that's the same for everything. If you tell your kids, you got to clean your room, and you don't tell them when, that room might get cleaned in a year. If you say, you got to clean your room or you're not going to the football game Friday, that room's going to be clean before 3 o'clock on Friday. So if you put a deadline, that's where it starts. Compliance starts with a deadline. Then people figure out how to meet the deadline. And that's the meaningful action that will solve the housing crisis. It will help because it will get these applications done much faster, and houses will not only get built, they will get sold and they will get occupied. And other jurisdictions figure it out. You can, for example, Madras, they hire a third party to do it. There's nothing that prevents the city from saying, okay, we don't have capacity. Well, okay, we're going to farm some of this out. There's qualified engineers. This is engineering review. It's not, they're not exercising discretionary decision-making in this process. That's where, the city might have a point. We can't compel them to do some discretionary process within a certain period of time. Only, they have some with the state laws, but that's different than simply reviewing engineering. I think a deadline would be very appropriate to impose on cities to say you have to have it done. So that's my main response. If you have follow-up questions, I'm happy to.
Yeah. Are there any other cities that impose such a deadline, or are they just doing it? They're just getting it done faster without.
We're not aware of a deadline. They're just getting it done.
May I speak to that as well?
Yeah.
Davies? Oh, great. The city has a policy that came out January 10th, 2023. It was revised. It was Community and Economic Development Department's policy of expedited permitting process for affordable housing projects. In that, they have required timelines for different things, for applications and all that. On the engineering side of that, it's the last 2 paragraphs. It says infrastructure applications, and I'll read verbatim on this. Once any deficiency on the application or other plans have been addressed through pre-screening, review will start within 15 business days, but no later than 20 business days by all divisions. Date of first review of completion is dependent on the complexity of the project. Subsequent correction reviews will be started within 15 business days, but no later than 20 business days. We read that when me and Mr. Kobach were coming up with this, and we thought it was reasonable to give them twice as much time as what they have in this policy. And that's why we came up with that number. Honestly, needed housing and affordable housing are both needed housing. So we didn't really understand why it would be any different than what this is. And if they can commit to this, with affordable housing, then we thought they could commit to something that was twice this long for all needed housing. That's how we came up with that.
And that deadline was an engineering review.
That was the portion under engineering, yes.
Is that
Engineering
policy? So I saw references to the policy. Is that policy itself in the record?
I don't believe it is. I'll have Mr. Kobach get it in the record today.
I got to go find it.
I have it in my hand. I'll send it to you.
Thank you. So does that answer your question on?
Yeah, that's
okay.
fine.
So, the next, I want to talk about 2 other issues, and I've talked about the removal of encroachments and easements, encumbrances and easements. And I think that's where one of the comments you just made, the city had said, well, the statute doesn't dictate what the city does. It's just the ORS 92.0903 basically says that dedications under state law have to be free from restrictions or the dedication has to be free of restriction or reservation, but it can be subject to certain private easements and encumbrances. So what we were arguing is, well, their policy, their new statute or ordinance, I guess, is inconsistent with state law, because under state law, you can dedicate subject to private easements. So what's the problem? And then I think the city is saying, and I can't really disagree with it. The city is saying, well, that's state law. We want to have a different standard. My point is that different standard violates ORS 197307. It causes unreasonable cost and delay. And our example that we gave you in Bat's review is very good. Is when there's an existing easement, and your opponents control that easement, the city's saying you got to get rid of that easement, stops your development, right? Because how can you go to your opponents and say, hey guys, we know you hate us, you hate our development, you've opposed us all the way, but hey, would you sign this termination of this easement to facilitate our development? That isn't going to happen. And so then the city said, well, we have this discretionary track. You can submit it to the city engineer and they can consider it on a case-by-case basis. Well, I showed you in Exhibit 5 how that works. If the city engineer supports your project, maybe he'll do it. If he doesn't, like ours, he's going to tell the neighbors, hey, here's your argument. We're not going to do it in this one. So, I mean, it's a problem. That's the point we're making.
It's even worse than that, if I can interject, because where the city is interjecting this is after we've got land use approval, after we've built the whole subdivision, and when we're trying to go get a final plat. Now we've bought property for millions of dollars. We've spent millions of dollars for infrastructure. And now on the final plat review, after we've had to go get it substantially completed and spent all the money, now then they're going to go interject this at the end. It's absolutely ludicrous. And every single project that's out there typically has some type of easement on it, be it with Pacific Power, be it with a private easement, be it with a private water company, be it with financing. That's an encumbrance, right? And so that is completely a discretionary thing. There's lots of projects out there that they've done for years and years and years and years and years since the beginning of time that hasn't had any issue or any problem with any right-of-way issues. And so for them to bring that up at this point in time, especially at the precarious time that they opposed 3 subdivisions that I was going through, the city opposed of them, and we got them through with a hearings officer, for them to interject that comment and then pass that in the middle of me getting these approvals done and getting them approved by a hearings officer is suspect at best.
Is there, I'm just going to throw this out there and the city can respond. I mean, some of this stuff is just development is messy, you know, the city knows that, the applicant knows that. There's going to be stuff that has to get worked through. But I hear what you're saying is, like, to the extent that we can get rid of that stuff that causes delay, let's do it. Is there a way to put that requirement early in the process, like add that to a approval criterion, so that can get flagged before everything's all done, as a fix for, you know, any opportunity that we can to clarify or avoid delay? Let's try to figure out how to do that, which might be a better solution than just changing the language of that.
I can give you my thoughts on that, but the way the current structure is, well, there might be, but the way the current structure is, I don't know that it's possible, because the dedication almost always comes at the end, right? So you submit your application, and in the city's vetting of the application, it tells you what right of way you're going to have to dedicate, where your roads are going to be. And so the dedication usually comes late in the process. And so I don't know that even within the current structure of what I understand the code to be, I'm not sure you could get it vetted earlier, but I don't think that's really the important point, because even if that provision is early, doesn't it still discourage housing? It's taking property off the market that's zoned residentially just because there's an encumbrance that we can't remove. So because the focus here is, what is unreasonable cost and delay? Does that provision cost unreasonable delay whenever it's interjected into the process? I think it does. And I just wanted to add, before Mr. Kine gave his insightful comments on this issue, that not only did it come up at an odd time in our application, this amendment, is there's a subdivision next to us between Century and the Bachelor View ones, where the city accepted dedication subject to the exact same easement. Never a problem. No problems identified in their testimony with that. It was a 65 lot subdivision. I would say it's 80 to 90% built out. People, nice families are living there, using that road subject to that easement. Not a problem. So I guess the questions I ask my rebuttal is, what changed? Why does the city have a compelling reason to change how it treats dedication and existing easements on that dedication from 2019 to now? What purpose could be served? If it was okay in 2019 and there's never been a problem identified, why would you subject applicants going forward to a new standard, which we have demonstrated causes delay? It causes expense. it causes a lot of problems, and it could stop certain developments in their tracks. So that's what I wanted to point out on that. And if you don't
Can I
have
go interject one thing too, Chris, before we
Sure.
move on? I'm sorry. I know you have a train of thought or whatever, but I want to go
train
back
left.
to Hearings Officer Davies' comments or whatever. You know, it is subject to that. They do know that at the time we turn in the tentative plat approval, because we have to turn in a preliminary title report. And so this is nothing new that comes about on it. You know, we did go hash through all of those things, and we had to, you know, what I'm finding out, I've been doing this for 30 years in Bend, Oregon. It has never been any tougher than it is now. I hear that from everybody all along. But what happens is you've got to go through and you've got to go find all of these little things that the city can go change and go do, and you don't even know what they're going to be. And yet you've got to try to go and make sure that you get that done in the tentative plat approval as a condition of approval, to go make sure you head them off from something they'll do on the back end. And that is tiresome, and that has not been the case of what's been going on in the city of Bend for years. The engineer that I am using for these projects used to be the city of Bend assistant engineer. He knows what this is. He is completely frustrated about how this whole thing has been going down. You've got lots and lots of personal preferences from, you know, everyone that's sitting in that room right over there to the engineering folks that come in and give you half truths, half things to go create more frustration and more delay. And thus, it's weird how the city of Bend has the highest median household price in all of Oregon. It's supply and demand, and the city of Bend is artificially, through some processes over there, and that is creating that. One of the things that happens that I feel horrible about, honestly, is their staff is probably just not trained well. And it's just a problem from their management and their whole system over there, is that they have a code that, just like you had mentioned earlier, that should probably just go get modified with the UICs, because it doesn't match what their own study and that they commissioned matches their code, right? Well, that's their whole code. Their whole code is like that. They don't understand that their code, new hires come. And then there's the federal, you know, constitution. And so when you come over there and you come in, the new hires in there, and even the new engineers that are reading this, they think that whatever is in the Bend code is the Bible. But yet the Bend code doesn't even adhere to state law, as we've shown. And they've admitted, because they changed two of the things that we had over here, the condo plat review and the whole thing about the engineering review fees. That's just a small taste of the entirety of the code that is inconsistent with state law and federal law. I've been doing this 30 years before any of those people in that room were there, and it's the hardest it's ever been.
Well, I was just going to sum up. There were two issues that the city said are moot. We agree with one. I think the condo, if they're going to remove the condo review, that would comply with, we understand the state requirements and eliminate that delay. And the fees, I'm not sure, we don't accept that the city under the statute has the right to say you have one of two options. Either you pay our estimate, or we will comply with the statute and give you actual costs. And I think in that publication, it was suggested that the actual costs would be more. So it's kind of like, yeah, you can exercise your legal right for actual costs, and we'll give it to you. We don't have that information now, but we'll get it to you. But it's going to be more. And so we think that you know, it should be one, actual costs, and the city should track this, because it'd be interesting to see since it takes on average a year to review all of these infrastructure plans for residential housing based on our survey of the engineers in town. It'd be interesting to see where those hours are going and what's actually going into that review, because if they can be prepared in a fraction of that time from scratch, it would seem like there's got to be some illuminating information if the city had to come in and say, here's the bill and here's exactly what you our customer are charged for. And then we think that's what the state law actually requires, if they're going to charge a fee. If they don't want to charge a fee, then they don't have to give us anything. So that's our position on that.
So are you saying that the state law does not allow what they're proposing, which is the option?
It doesn't say that. It says they can charge if they can
And what,
charge for
which,
their
can you remind me what statute that is?
ORS 92.097.
197, okay.
And I read it to say there's one option. They can charge a fee if they charge the actual cost of providing the service.
And if
It
they
doesn't
don't,
say.
if they don't charge the actual cost, then it implies that they can't charge anything.
Or they have to give up their review right. So that's really what we wanted to say in our opening remarks. Again, we think the rebuttal testimony and information we provided is really kind of a great roadmap to you, because we were able to you go to school on what the city was saying and really kind of get it down to the core essence of what's causing the delay, how much delay is there, and really what is the impact. And so we know you'll read that attentively, and we think it's very important information for you to have. Thank you.
Okay. I don't think I have any other questions. Thanks for that. And so then City of Bend.
Thank you. I'm Ian Lighthizer with the City Attorney's Office. I've got Colin Stevens, our Community and Economic Development Director, and Russ Grayson, who's our Chief Operating Officer, with me. So I'm going to go through some things, and please feel free to ask questions or get Russ or Colin involved at any point. I agree with Mr. Kobach. I don't think we're going to be here till 3. I think this was set for 2 hours between 10 and noon. I'm cautiously optimistic that will be more than enough time. What Mr. Kobach described at the beginning, and he spent 10 or 15 minutes on this, was really describing the land use approval and then permit, both engineering permit and building permit review processes that happen, especially between tentative approval and a final plat approval, that happen in pretty much every city in accordance with the way ORS 92 is set up. So Mr. Kobach described that process and focused on how it works in Bend. What I didn't hear was any suggestion that it works differently in other cities. And I think that's important, because some of this argument from the requester seems to be, at its essence, the City of Bend does things or makes applicants or developers do things that either aren't necessary or aren't required or are outside of the norm, or that other cities don't do. I don't really see any examples, much less evidence that's the case. So I'm going to move through, I think, the 6 areas of concern in the way that DLCD staff frame them, because I really think that I understand what Mr. Kobach is saying, that they have various complaints and issues, and we now have these 6 buckets, and maybe all of their issues don't fit into only one bucket. But I'm going to move through the 6 buckets, the 6 areas of concern, because I think that's what's been kind of referred to the hearings officer by the commission. So the first one: misaligned timelines of planning and engineering reviews resulting in tentative plat expirations. The headline here, and you will see this in the declarations that were submitted today, the city's additional, I think, 14 pages of limited written testimony. There haven't been any. There haven't been any expirations. The city conducted an additional review. We started way back in 2015, January 1st of 2015, up until, I'll say, the present. Technically, it may have been last week when we finished this review. There have been exactly 0 expirations of subdivision approvals or site plan approvals. So you will see, I think it's noteworthy, in the requester's submission on September 13th, they argued that the way city does business puts approvals in jeopardy of expiration or in peril of expiration. I believe they use both of those phrases. The facts are that there haven't been any. There haven't been any meaningful expirations in terms of subdivision or site plan reviews for almost 9 years, from January 1 of 2015 to the present. I don't know what it would have said if we had gone back further, but we felt like going back to 2015 was enough. So there haven't been any expirations that the requester is afraid of during that time for subdivision or site plan approvals. Our data show that there had been a grand total of 3 expirations of land use approvals during that almost 9-year period of time. 2 of them were property line adjustments that expired for, I think, reasons that are explained in the declaration from Colin Stevens that was submitted today. One of them was a partition that was just a problematic project that the owner eventually, I think fairly recently, has given up on. But in terms of what we're really focused on here, site plan approvals and subdivision tentative plan approvals, we haven't had any expirations. So I understand the hearings officer, at least as I understand it, has said in the order on the threshold issues, we get to look at some specific applications, some specific development approvals to sort of figure out whether there has been or whether there is a state of noncompliance or programmatic noncompliance on the part of the city. I understand that. We're going to talk about some of the specific applications, but when you step back and look at what is the real problem here, do we have a problem of the city's processes resulting in expirations of land use approvals that are intended to get housing on the ground? We don't, because there haven't been any. So that is really, really important. There was some discussion during Mr. Kovac's presentation, and I appreciated these questions from the hearings officer about what actions could the commission take if indeed they did find a problem. The presentation from the requester is really focused. I think it's focused on this. I think this administrative, admittedly by Mr. Kovac, non-discretionary, which I take to mean non-land use or non-land use review process of engineering plans and building permits. But their argument seems to be that it is the way city staff do those things that results in these expirations. So importantly, one, again, there haven't been any expirations. But even if those processes resulted in applications being in jeopardy or peril of expiration, and I do not think there is any evidence that that's the case, the question here is, what could the hearings officer and the commission decide to do about it? And this goes back to 197-320. And the way that this petition has been framed by a requester is under subsection 10 of that statute. And that means we are looking at this question of whether the city's approval standards, special conditions on approval of specific development proposals, or procedures for approval don't comply with the needed housing statute. To the question of what could the hearings officer or the commission do if they found a non-compliance problem, I'm extrapolating a little bit from the hearings officer's decision on the threshold issues, but it sounds like it's a question of the expiration period. Is this 2-year expiration period and the framework for an extension that the city of Bend has, is that sufficient? Is that enough time? Or is the way that is built, and that is obviously in our development code, that's a land use regulation, is the way that is built to the extent that expiration period is a special condition of approval? And I think that's what the hearings officer has found. That's why there's jurisdiction on this. Is that long enough? So how do you answer that question? Well, do people have problems? Do we have expirations of these kinds of land use approvals that we're talking about? But the data show that we don't, and that's just a fact. I mean, that is factual. That is backed by sworn testimony. There really isn't, and I think can't be, any dispute about that. We noted in our September 13th filing that other cities around the state have various frameworks for land use approval expirations too. There's no city that I know of, and that doesn't necessarily mean there isn't one, but there's no city that I know of that says once you have approval, that just sits there forever. There is an interest that cities have in approving things to get projects moving and creating some incentive for the developer actually to get going, so we don't just get entitled properties that aren't doing anything. So other cities around the state have various frameworks for how long their approvals exist before expiration. The duration can vary, the frameworks and availability of extensions can vary, but it's our position that the city's framework is kind of right in the thick part of the curve in terms of what other cities do. So back to this question of what the commission can do. If the commission finds non-compliance on this issue, the city could order the city to do some things, including amending its land use regulations. We're saying there's not a problem. We're saying this isn't actually something that happens. So there's no non-compliance that would give the hearings officer or the commission authority to take that action. But if an action were taken, that's kind of the universe of what could be ordered. What the requester seems to have talked about, I think Mr. Kovac, I appreciate him acknowledging there was maybe a little bit of, if not ambiguity, that this was a fair question. What can the commission really do if it finds non-compliance? And I know Mr. Kovac didn't say, you're right, the city's right. The commission can't require the city to hire more engineers or conduct every aspect of its administrative processes differently. So I don't want to, I mean, I appreciate that. I don't want to put words in his mouth, but I think that's the real question here is what can the commission do? Tracking the hearings officer's order that the reason there's jurisdiction here is because these special conditions of approval require these things to get done within a certain period of time. And that's from the code. The action that the commission could take was say, okay, city, you've got to do something to give people more time to do these tasks, not you've got to do these administrative tasks differently. So we don't think there's a basis for the hearings officer to order that. We don't think there's a basis for the commission to find that. But to the extent that somebody disagreed, we think that's what can be done. Moving on to 2, unreasonable delay in reviewing and approving engineering plans for required public improvements. This is interesting. Mr. Kovac first talked about the data that the city provided, the graphs, and I think understandably he focused on what I'll call the right side of the graph. If you look at each of these graphs, as you move from left to right, you are talking about time increasing, the number of review cycles increasing. And the requester's argument here seemed to be, well, if you look at the right side of these graphs, the requester isn't alone. They're not the only one that has required a certain high number of review cycles, or they're not the only one where it's taken a long time to approve either their permits or applications. That's true. That is true. The city is not saying the requester is the only one that has these issues. But what I would request that you do is do something that Mr. Kovac didn't talk about. Look to the left side of the graph. And again, we're talking about overall programmatic compliance. The city's data show that the vast majority of applicants get through the land use process quicker, they get through the engineering review process quicker, and they get through the building permit process quicker with fewer reviews and less time. So back to what we are talking about today, programmatic review, overall compliance. Is there a state of noncompliance? We think those graphs show that there isn't noncompliance because you look at this thing as a whole. Requester's not alone, but as you move left to right on these graphs, the pattern you will see is that the light blue bars, the requester's projects, the requester's permits, the requester's engineering reviews, the light blue bars get more prominent as you move from left to right. So that is the right way to look at the city's data in determining overall compliance. There were some other comments from the requester. I'll speak first to the argument they made that other jurisdictions all get it done faster. And I think this was focused on engineering reviews. And I'm assuming the basis for this argument are some emails that were attached to the September 13th submission from the requester. Those emails, generally speaking, are inquiries from the requester to city staff at various cities around the state, either in planning or engineering or some associated functions, essentially asking, what's your average time, your average turnaround time for first review? That's generally speaking the question. Generally speaking, the answers were not, we always get it done in X time, or we always get it done faster than the city of Bend. The answers generally were, here's what we try for, but it kind of depends. It depends on the project. It depends on the nature of the drawings. It depends on how many review cycles are required. That evidence is not compelling in the way that the requester seems to think it is. That evidence actually supports the city's position that there are projects that get through quicker with fewer reviews, and there are projects that take more time, involve more reviews. It just depends on the project. I'm not going to say the quality of the engineering reviews, but it just depends. When you look to the extent what requests are submitted, again, these general emails, responses to general questions, to the extent you consider this evidence of anything, it is evidence that it depends. Last note on this topic. Have not had a chance to review it in a lot of detail yet, but the additional written testimony that requesters submitted today, and I'm going to note that it's more than 15 pages. It's 28 pages of additional testimony. I'm going to note an objection for the record to that because the contested case hearing specified that the additional limited written testimony that could be submitted at the hearing today would be limited to 15 pages. So I'm going to note an objection for the record and recognize that the hearings officer, in the interest of truth, justice, the American way, is probably going to admit it. That said, some of the additional pages that they submitted in excess of 15, and I honestly cannot believe I'm having to talk about this. It's an anonymous survey, allegedly, of engineers that do work in the city of Bend. I really don't understand this. And I'm going to compare and contrast it a little bit to what the city submitted today. The city submitted 2 additional sworn declarations. I'll talk about them a little bit more in a minute. This is sworn testimony. The requester submitted pages that purport to be results of an anonymous survey. There is no way to know what this is, who was surveyed. There's not even a declaration from anybody saying, you know, I conducted this anonymous survey and here's some stuff about it. I mean, nothing. So I just don't really know what you can make of this. You know, we're really big picture talking about substantial evidence. You know, is there substantial evidence of noncompliance? I think most of the time when courts and hearings officers and other tribunals are evaluating substantial evidence questions, they're really thinking about how much is there, what's the quantum of evidence. But here, I really have to ask you to think about the quality. The city is submitting sworn declarations, sworn testimony with real data. I'll, again, get back to that in a minute. The requester is submitting general emails with general and very qualified responses and an anonymous survey. Here I would strenuously request that when you are considering this and writing an order and thinking about the substantial evidence question, you think about the quality as well as the quantity. One last note on this survey. So the survey was presented as, I think by Mr. Kobach, as indicating, maybe it's Mr. Kine, I can't remember, indicating, I believe, that 100% of survey respondents responded, saying that their, I think, permit reviews, maybe for engineering, for public infrastructure, maybe it's building permits, took over 12 months. I think that was the statement. 100% of them said it took over 12 months. And then, you know, Mr. Kine said, and he called out that 3 people in this room or that room, I think he said, or other people at the city demonstrate personal preference, I think, toward or in favor, and I'm inferring a little bit, toward or in favor of other applicants or other engineers, I guess trying to imply that they get through the process quicker. So I'm just pointing this out to say, I don't know which is which. Is it 100% of people in this unsourced, unattributed, unscientific, to put it mildly, survey saying it takes them all over 12 months and they're sort of all subject to this bad process or bad city behavior or inefficiency or whatever it is? Or is it that other people get through the process quicker, presumably in less than 12 months, because they get preferential treatment? So I just heard both things from the requester. I don't really understand either one. I'm going to move on to the third area of concern, and this is the require. And I'm phrasing this, I think, sort of paraphrasing from the DLCD staff report. This third area of concern, the requirement to extinguish private easements prior to public dedication. And the requester got pretty, I think, pretty heated about this during his testimony. A couple things they didn't say. They mentioned this in their September 13th filing. They mentioned that there's a lawsuit, that they're the defendant in a lawsuit from some neighbors or opponents of the project. The city is the defendant in 2 lawsuits. The city is now a co-defendant with requester in 1 lawsuit. The city is a standalone defendant in another lawsuit from kind of the same group of people that are opposing requester's application. One of the reasons the city is a defendant in 2 lawsuits, where honestly we have a kind of a similar position to the requester, is that we accepted this dedication deed. You heard a lot from the requester and his attorney about the city refusing this, or the city not doing this, or really the city imposing this amended development code standard. I think the implication was improperly after the tentative plan approval of the subdivision, but before the final plat approval. That's just not true. The city accepted the dedication of this right-of-way subject to this easement, this encumbrance, for a couple of reasons. Again, that is water under the bridge. That happened. And the city did that for a couple of reasons. The city's decision, the hearings officer's decision, which is the city's decision, said the applicant needs to do this. They need to dedicate this right-of-way subject to this private access easement. The city construed that as effectively saying this applicant needs to do it. The city needs to accept it. So the city accepted this deed. So to argue that this standard was improperly imposed on the applicant because goalpost, or that it's just improper because it leads to unreasonable cost and delay, I don't get it. The city accepted the deed. The city is now a defendant in 2 lawsuits from people saying you shouldn't have accepted that deed, or you're infringing on our easement. This is an inverse condemnation problem, et cetera, et cetera. And I'm going to say this, I didn't put this in the record, but I'm going to mention it anyway. And I didn't put it in the record because I didn't think I'd need to. And so I want to proceed a little bit cautiously, but Mr. Kobach and I had a conversation about this issue back in April of 2023 on the goalpost issue specifically. You know, the city has amended its code. The client, Mr. Kynes, already got tentative plan approval for the subdivision. The city's amended its code. What is the goalpost implication of this? The code's changed between tentative approval and before final plat was applied for. I agreed with Mr. Kobach. Yeah, this would be a goalpost problem if the city applied this standard. Mr. Kobach knows that, told him that in April, got an email, not really a big deal, but I just want to provide it as some context that like this, the argument that this is going to cause unreasonable cost and delay to the extent of discouraging needed housing, it hasn't happened. The city has accepted the deed. That Bachelor View 1 application where this issue was implicated. Again, we mentioned this in our September 13th filing. That didn't go to a hearings officer to get a ruling on this issue. It was elevated to a hearings officer because that's something the city does under its code with certain applications, especially those that might be controversial. And we want that non-staff fact finder to render the city decision. And so that's what happened here. It wasn't because there was a disagreement. Mr. Kynes didn't have to take it to a hearings officer. It went to a hearings officer for the tentative subdivision application. That got approved. It was with the condition that the applicant had to dedicate this property subject to the easement. The city ultimately accepted it. And then we have a couple of lawsuits, I'll say, sort of on the side. That's not because of the city's standard. The neighbors who were opposing this development were coming up with their arguments about this long before the city amended its code. On that code amendment, and you'll see this in Mr. Stevens' declaration submitted today, and I think we've alluded to this in our earlier filings. The requester keeps saying the city's long had a policy that it would accept property dedications for right-of-way, only looking at kind of the reservations or restrictions framework, but the city has accepted or has a policy or practice of accepting right-of-way subject to private easements, running the gamut, who knows what, from time immemorial, and they've changed their policy or practice. That's just not true. I'm the lawyer here, I'm not testifying, but we said in our submission, it is true that there is right-of-way around the city, various places that the city has accepted that is encumbered with easements. That does not mean that the city has just done this. I cannot tell you how much time my office has spent over the years trying to figure out how to get right-of-way dedications cleared of encumbrances like access easements, utility easements, et cetera, that might interfere with the city's ability to manage this public resource, this public right-of-way. That's something we have dealt with for years. This is not a policy change. And, you know, the requester pointing to a land use approval near these bachelor view developments from several years ago where right-of-way was dedicated subject to an encumbrance. Yes, that happened. But it is all over the map, literally and figuratively. The city has long tried to get property cleared of encumbrances before it's dedicated for right-of-way. I mean, the reasons for that are obvious. Like we went into this a little bit in our September 13th filing, but these two lawsuits are evidence maybe of why that is an important and justified city interest in getting this done, right? If you have encumbered right-of-way and you accept it, you have people saying that's a taking. You have utility companies saying, well, we can close down your street because we need to do a repair. You have a private party saying, you know, you're encroaching on my private right to do A, B, and C. The city needs to protect its public facilities. We're required to plan for them under Goal 11. We need to do what we can to make sure that right-of-way is not encumbered, or at least is not encumbered to a degree that conflicts with the use of that property for right-of-way. So, and again, I can't say this enough. Requester's just wrong. Mr. Stevens testifies and proves that he's wrong. The city's never had this policy. Again, to be clear, that doesn't mean that there isn't encumbered right-of-way around the city. This is not a perfect system. As you said, hearings officer, land use and development can sometimes be messy, but this is something that we've struggled with for years, and the goal and objective of getting unencumbered right-of-way dedications is, it's not new and it hasn't changed. Last comment on this issue, this third area of concern related to the statute. This is 92090. You know, I think requester reads this, and this is subsection 3. It says no plat of a proposed subdivision or partition shall be approved unless, and then it's A, B, and C, and I'll talk about that in a minute. It does not say the city must approve a subdivision or partition plat if. That is not what the statute says. Requester is, without saying it, I think they're presenting a reading of it that says that. In our view, it establishes really a floor that the applicant has to meet for a city to approve a final subdivision or partition plat. Subsection C, I'm going to read this. This is one of the things that has to happen. The subdivision or partition plat complies with any applicable zoning ordinances and regulations, et cetera, et cetera. So the city has in its development code now a provision that will apply, assuming there is not a goalpost problem. That is why it wasn't applied to Batch Review 1. But in the future, that is the applicable ordinance or regulation that the statute seems to allow for. So we don't think there's a statutory problem with this. It's consistent with previous practice. It wasn't applied to BV1, Batch Review 1. The deed subject to the encumbrance was accepted. So moving on, area 4, area of concern 4. This is framed as arbitrary fees. So, you know, one thing we didn't put in the record because it wasn't really presented was the city's fee study. So, and I'm bringing this up because Mr. Kovac said it would be interesting to see what goes into that review. This review that the requester says is subject to the requirements of ORS 92097. So the city does a fee study, and that is data, that is analysis that reviews the actual cost in terms of actual time of city staff to review and do the work that's covered by ORS 92097. And primarily for purposes of this case, we're talking about the engineering drawing review. So the city conducts a fee study that arrives at the amount based on the actual time and actual cost. And the fee is set as the average of that. That is what people have paid. When the requester brought this up and sort of highlighted their view of what 92097 requires or allows, the city amended its fee schedule to say, well, we have this fee study, we're gonna do that. But if somebody wants to pay actual cost, they can do that. And we have a mechanism for tracking actual hours. And you know, I didn't really like the implication from Mr. Kovac that you know, his client would sort of get stuck with that and it would necessarily be more than what he's paid in the past. I mean, to the extent the city sent that signal, I mean, I'll apologize for that. That wasn't the intent, but based on the data that the city has, the applicant, the requester, excuse me, their permit, their applications, their processes, the things that they submit that the city provides services for subject to 92097, they typically take more time than the average. So if the requester wants to go that route, they can do that. That's fine. They have that option. Call it speculation on my part, but it's based on the data. They might be getting a better deal if they just use the average cost, because the average, the typical, is less time, less actual cost. So that's the point there. I do not see how creating that option, which I think the requester would agree complies with the statute, somehow invalidates the way the city has done it before. So main point is the city's already made that change. Appreciate that the requester acknowledged that area of concern 5, which I'm not really going to talk about, has been mooted because the city is going to eliminate that condo.
The condo one?
So, yeah, that's going to be eliminated. We expect that will be final by the end of 2023, and that's pretty simple. It's striking it out of the development code. And as Mr. Stevens testified to in his declaration, that is underway. It's going to happen. We don't expect there will be any holdup. So appreciate their acknowledgement that seems to be mooted, but really we think 4 is mooted too. So 6, area of concern 6, skipping to the last one, unreasonable cost and delay caused by the city engineering department's underground injection control policy for stormwater facilities. So the dialogue, I think, between the hearings officer and the requester earlier, I think it cleared up some of the things I was going to say. The way this was presented by the requester was that this was some policy or judgment or subjective belief of city staff related to, and I'm paraphrasing, you know, misconceptions about the city's WPCF permit or DEQ regulations, et cetera, et cetera. And I understand the argument, but as we clarified in our September 13th submission, no, this was actually application of the city's standards and specs. And we outlined this in the argument. The development code essentially says on this topic, these facilities have to be constructed in accordance with the city's standards and specifications. So that was applied, the standards and specs. This isn't some subjective belief. One thing I'll say acknowledge is that we have a standard and specification that says you can't do this. You can't have UICs within 500 feet of a drinking water well. There is data and inferences, I think, from our WPCF permit through DEQ that I'll say DEQ's concern might be different. I think it's fair to ask, does DEQ require that degree of groundwater protection in terms of separation through either their regs or the permit. And I think it'd be fair to conclude that no, they don't. The city is always interested in looking at its regulations, including its standard and specifications, to the extent they're linked to and through the development code. To ask the question, is this necessary? Do we need to do this? So I think it was worth clearing up what was applied on this topic, not a subjective belief, not at least at the end, a misunderstanding of the permit, but simply the city's clear and objective standards and specifications. But I think the city is willing to acknowledge it's open to looking at this. Is this standard, not is it protective enough, but is it too protective? Fair question. But in this case, again, this went to a hearings officer. This was in Bachelor View 1, I believe, the same application that triggered all of the discussion about the standard to remove encumbrances. The hearings officer decision.
This was hold on. So this was the tentative
Yes.
subdivision
Yes.
approval that got elevated to the hearings officer. And the
The
hearings
applicant, yes.
officer was the one who,
Yes.
was that the decision that discussed the DEQ permit and all the study and all that?
I believe it is. I believe it is. And so, yeah, and to be clear, it was the application that got elevated, right, to the hearings officer to render the city decision. That city decision, and Mr. Kovac said, "Oh, the city's argument is going to be, well, we got through it." I'm not, I hear that, but worth pointing out, the city's decision, as rendered by the hearings officer, was the applicant can do the UICs as they're proposed with some conditions to demonstrate groundwater protectiveness within under 500 feet from, I can't remember if there were one or more wells. So that was the city's decision. The city allowed this. This was going to the hearings officer anyway. It's not like the city rendered a decision and didn't allow UICs and the applicant had to appeal it somewhere to get a better decision. The city's decision through the hearings officer was to allow this. But again, I'll acknowledge that the city is open to looking at this standard to determine whether it's kind of the right balance between groundwater protectiveness and the needed housing principles that we all know are important.
So is confused about the city's position on the hearings official's decision? I mean, is that a decision that the city feels like it's bound to and will abide by in allowing these UICs within the 500 feet?
In this application, yes.
Oh, in this application.
Yes. I mean, that is the law of the case, so to speak, in this application. What I'm also saying is, does this also raise a fair question about whether that standard is appropriate? Should we look at this? Is that the right balance between groundwater protectiveness, which I think we all understand, needed housing, we all understand? Yes, this is kind of a yes and, right? So that's the city's answer on that one. I think this is an example of something that you see honestly from requester is when there is uncertainty or friction, like how does this thing fit? It becomes a bigger deal than it needs to be. Again, application was approved, and it was over and done with. So I'm going to wrap up. So I think I've gone through the 6 areas. I'm going to go back to kind of the big picture. We have cases. We have Schoonover. We have Landwatch, Lane County. I haven't looked. I expect that Mr. Kovac addressed those in what was filed today. I do think those are actually pretty straightforward. Is there a generalized failure? Is there a state of noncompliance? In those cases, especially Landwatch, Lane County, the requester there presented dozens of actual violations. Here we have friction, we have arguments, we have implications about other cities that aren't particularly, I'll say, compelling. We have an anonymous survey, to the extent we can even call it that. and we have statements about timelines and how particular projects went. And when you are considering the substantial evidence question, I would ask you to consider all that and look especially at the declaration of Colin Stevens that we submitted today. Mr. Stevens goes through in that declaration a timeline for, I think, every project that the requester raised in their September 13th filing. I'll note that there were a handful of additional projects there. The requester is focused on, I think, about 4 or 5 of their own projects up to this, from the letter to the city back in April and then the enforcement petition in June. 4 or 5 of their projects, more or less. And in the filing on September 13th, they seem to have looked around through the city's city view system and found a handful more, made representations about the timelines of those projects, sort of what happened, when an application went in, how the city did its first review. And it's sort of a high level 2 or 3 sentence assertion about a timeline intended to make the city look bad and suggest that there's unreasonable cost or delay throughout the system. What the city has done and what it submitted today is walk through the actual timeline of every one of those projects, count the days, the number of days that the ball was sort of on one side of the net or the other, with the applicant to respond to what the city said, with the city said to review what the applicant submitted. So we go through this sort of volley by volley. And again, that is how the process works. The requester seems to be saying there shouldn't be so many volleys. No one wants there to be as many, but when the city makes comments and the requester doesn't then resubmits and doesn't respond to all of those comments, or something changes, the city has to point that out. Any city would do that. Every city does that. And that's what you're seeing in these, 5 or 6 page comment letters, which again, the requester, he's not the engineer. I don't think he reviews those. He may not know exactly how that works. But when you look at the declaration from Mr. Stevens, you will see these timelines and these volley by volley day counts that they're not intended to make any particular requester look bad, but they show that these applications, they sit with the requester or the applicant, because not all of these are requesters' projects. Sometimes they can sit with the requester or the applicant for a long time, and then they get back to the city, and then they sit with the city. And when you look at the days here and the days there, you have to look at that when you are trying to answer this big picture question of, is it something the city does that is substantial evidence of non-compliance on a programmatic level? Our position obviously is that there isn't. We have these project specific examples, but when you break down the projects, it's not really the way that the requester presents it in terms of the timeline. When you look at the graphs, the data the city has provided, especially again, starting from the left and reading to the right, it doesn't show any programmatic problem. Requester is not alone in sometimes needing a lot of help and a lot of review cycles, but most people, most applications, most applicants, most developers don't need as much time. And that's I think the really important issue for determining programmatic compliance. And then I will close by calling out the letter that Mr. Stevens sent to the requester. I want to say it was June 20th. It was the city's initial response required under the statute after it gets notice of a potential citizen initiated enforcement petition. Mr. Stevens pointed to, I'll call it the really big picture stuff. City review times going down. Across the board. The city's housing needs and the data showing that we are getting units approved and they are under construction or in the pipeline. We are, again, programmatically on track to meet or exceed the housing need in this community. Tonight at the city council meeting, it hasn't happened yet, but there's a master plan that the council is going to be considering, and I have every reason to think they're going to approve it. We don't know how that's going to go, but there's a recommendation from the planning commission to the city council that the council approve a master plan, which is going to put almost 600 additional housing units on the ground. A month or two ago, there were 1,600 units that were approved. I mean, I could go back and back and back. I mean, the city has approved all of requesters' applications for needed housing. So again, programmatically, starting big, city is doing its job, timelines are coming down, housing applications are getting approved and constructed on track to meet the goals that we're supposed to be hitting under the housing needs analysis, our comprehensive plan. We're doing it all on a programmatic level. That doesn't mean there's not friction. When you dive into the friction that the requester has tried to illustrate on particular projects, it's not the way requester presents it. It's a mixed bag. Go ahead.
So is there, I know there was some general response, when this, I think it's when the petition was originally filed, or the notice of intent to file.
Yep.
Was originally received by the city. I think that I saw something that said that the city was dedicating a number of staff to talk about these things. And there was also, I thought that there was some explanation for a period of time when delays might have been longer based on new staff or short staff. Is there any of that type of explanation during this period that requester is looking at?
So I'll start that and then maybe turn it over to Colin or Russ, but the city did transition from its old permit system to a new one. And was that 2021-ish? And we acknowledge in one of the declarations submitted today, one of the projects that requester highlights, I can't remember, this might have been a project from a different applicant or developer, occurred during that transition time. And again, timelines are better now than they used to be. I think that's impacted by several things. One of them was the city's transition from the old, outdated, rusty platform to the new one. I think even Mr. Kovac said it was pretty slick. So that may be one of the issues. If Colin or Russ want to jump in on that, they can.
Yeah, I will. I'm Russ Grayson. I'm the Chief Operations Officer, and I was previously the Community Development Director and City Engineer. I will say, yeah, it was also during the time of COVID. We had significant staffing challenges, just like all other businesses and cities around not only the state but the country. We had about close to 25 to 30% turnover that occurred within our department. We also thought that due to COVID that we were going to see a slowdown, so we did not fill vacant positions at that time. And what occurred was exactly the opposite, where development sped up during that time. And with turnover and people leaving and trying to hire new staff, which is difficult, along coupled with the software, yes, there were longer review times that were occurring. Since that point, the city has been working diligently to get those review times down. And we probably have one of the most transparent reporting systems on our city website on review times for various applications with our desired timelines. And I'll turn it over to Colin. Colin can go through what has occurred over the past 6 months to get these review times down to acceptable levels from both the city standpoint and the community standpoint.
So yes, I've been in this position for about 1.5 years. And one of the tasks that I was assigned to when I took over was to get our review times into a manageable area. This is a council goal that we have. So as such, what I've done is I've worked with my staff. We established really 2 focus groups, one for our private development engineering permitting, and the focus group was the submitters, the private engineers who work in the private sector who submit applications to our staff, and the other was a similar focus group that was based on our building permits. So it was the design professionals, architects, et cetera, who do design work for building permits. And we had 2 separate meetings. We developed initiatives coming out of this. We're in December of 2022. I developed initiatives that I presented to our city council in January of 2023.
So this was all in the works before this petition for enforcement even got filed?
Correct. Yes. We developed
probably 5 to 6 different initiatives for each of those 2 divisions to implement to improve turnaround times. And those went into effect over the first 2 quarters of 2023. They're now both in effect. Many of them address the issues that are raised here. We now require a higher level of engineering design before we will take applications in, up to 90%, which is kind of an industry standard. And that reduces the number of turnaround times for
So
engineering.
explain that. Can you explain that again? Higher level of.
So we now, one of the initiatives, and this was agreed to by the private development engineers and our city staff. So this is a collaborative decision, was that they would prepare, the private side would prepare what's called a 90% complete plan set. That means that it's almost ready to go as far as construction is concerned. Before that, we didn't have a standard, so people would submit something that was only halfway done, or 50%, or 60, or 70, which took more review cycles for our staff to work with the development engineers to make it into a final plan set. So that's been helpful. We also now offer both pre and post meetings, in-person meetings with the design professionals before they start their design, and then we get their comments to help them work through that. Another thing that we're doing with engineering, I'm going to focus on engineering primarily, is we've instituted what's called a pre-submittal or a pre-screen process, where they jump on submittals when they come in to determine completeness right up front, and can get incomplete applications back to the applicant before they actually sit, so they don't sit in a queue for weeks before they get to the actual plans examiner to do the first review. So we're making sure that they're complete before they get into the engineer who's going to do that review. Again, these have been put into effect through the first 2 quarters of 2023. They're all in effect now. I would encourage the hearings officer to go to the city's website. You can go to the Community and Economic Development Department's website, and on the very
I'm limited to what's in the
Okay,
record,
yeah.
and so that's probably
Well,
not.
what you can see is that we have taken our engineering review times for tier 3s from what we have a goal of 45 days for first review. If you've asked, what's a reasonable amount of time, that is our goal, is 45 days to get a review back to the applicant on first review. That's published on our website. And then every month we show how we're doing. And previous to these initiatives going into place, we blew the 45 days pretty much every week. I don't have it up in front of me. But starting in probably February to March of this year, we have been under 45 days for that first review, all but 1 month. But that was one project that we had some difficulty with, which pushed us over, and I believe it was around 60 days for that review. But this is something that we pay particular attention to. It is on all of our staff's sort of radar, and certainly on my management teams, that these are the metrics that they're expected to meet on a monthly basis. And
So
we
that's
pointed out-
including the city's review of the engineering for those public.
So correct, but it's the first review. So it goes back, if you'll recall what Ian said, sort of this volley back and forth over the net. We don't have control once it goes past the first review over how long it takes that engineer to digest those comments, revise the plans, and get them back to the city.
Is there also a suggestion or a goal or a hope of subsequent reviews, or is that not really?
That's another thing that we have instituted, is I believe it's a 21-day turnaround for all review comments. We have an internal review of 2 weeks, but then we add in some time for some QA/QC from management if there's some questions that need to get resolved. So we say 3 weeks on re-reviews, but if it's pretty straightforward, it's the design or the review engineer can get it out in between 2 and 3 if they don't have to check with their manager.
Okay.
Can I make just a quick note regarding the record? Appreciate the comment on focusing on the record. Mr. Stevens, his June 20th letter, which was kind of the city's initial required response to the notice from the requester, does cite in a couple of places to a couple of those resources. So those I think are fair game if the hearings officer is interested in looking at that.
Yeah, I saw those
And
things.
I'll just add one more thing, just kind of at the high level. City of Bend has been one of the fastest growing cities in the country for, I can't even tell you how long. We put thousands of units on the ground every year. We have been a leader in the state in initiating new policies that are coming out from a state level, such as House Bill 2306, which is an early plating action program, that we were the first city in the state to initiate that, and other cities are replicating what we're doing. We've changed our development code constantly to allow new type of housing types to come through and to try to move things through quicker and comply with all the new state statutes and rules that are coming out. Because we understand the seriousness of the nature of the housing crisis. It is a consistent council goal that we have had for years to try to manage this growth. We have to do it in an orderly development. It is, and as Ian alluded to, it does get messy because of the speed and pace of which the city is growing. And we want to make sure that we're building systems and infrastructure that can be expanded correctly and grow as the city needs to grow. But I just would like the record to show that the city's pattern and practice has been to be a leader in the state to get housing on the ground as quickly and as and the quantity that is needed to support the housing crisis that we are currently experiencing.
Good.
I think we can stop there unless there are other questions. At least stop there for now.
Okay, yeah, I think that's probably it. I don't have any other questions. Does DLCD staff want to make comment before final rebuttal?
I don't have any comments, but thank you.
Okay, turning to final rebuttal then.
Thank you, Hearings Officer Davies. What I would suggest, maybe just out of efficiency, is if I could have Mr. Kine testify, and if he has to raise his hand, that's great, because I want him to explain the survey. City staff went into significant detail on its concerns about the survey, and I think Mr. Kine, once he explains what he did, the survey won't sound as nefarious or as cartoonish as the city made it sound. It actually, I mean, we didn't have a lot of time, but I think Mr. Kine did an excellent job in that short amount of time getting requests out to the right people to get the right information. So if that's okay, I'd like him to testify first, and then I can just go through a few items quickly and get us all on our way.
Okay, that sounds good. I don't know that I need to have you raise your hand or swear or anything, assuming that you will tell the truth, which isn't always a fair assumption, but yeah, explain the process that you did for that survey.
So yeah, I've been, like I mentioned before, I've been working in the city of Bend for, at least 30 years in real estate development. And so I've worked with, a wide array of engineers and all that, be it David Evans and Associates, Hickman Williams, AKS, Sun Country, some Anderson, who's now gone. And so, I'm thoroughly involved. The development community is a fairly small community. So, I'm talking with them. I have projects currently going with, not only Sun Country Engineering, but also with Beacon and also with Hickman Williams. And they all tell me the same story. And I asked them if they'd go give me written testimony, and they all said, no, we don't want to do that. We're worried about, the city having, issues back with us in doing so. And so then I talked to them and I said, well, if I did an anonymous survey and I sent it to all your engineering, would you guys answer it? And they said, oh, we'd be happy to do that. And so thus I ended up sending it to the 7 biggest engineering firms that do work throughout the city. And I, came up with the questions, and we did do it quickly, and you'll see those responses from those. But that is engineering firms in this town. And that is my declaration, and that's how that went down. While I have the platform, I always make Mr. Kobeck cringe when I do this, but I'll do it anyway. It sounds really great. I love to hear that the city's got this goal of 45 days and then 21 days, because we were asking for less than that or more than that. And so an enforcement action for 60 days and 30 days for follow-up should be no problem for them. Why are they protesting so much? It should be super easy for them to go do that if that's what their goal is. You know, they've missed their goal time and time again per the information that they've given to you. And so
what would be the consequence of, so if they put something in their code that said, staff, thou shalt do this within a certain number of days, what's the consequence if they don't?
well, here, and this is, you know, this is my opinion on what it is. So the state statute says they don't have to. They may go and have that, but when you're doing private development and public right of way, that the private engineers have the right to do that. It clearly states that. There can be no argument about what that is, right? And so then that private engineer has that liability to go make sure that those plans are adhere to the specifications, and then they have to go do the inspections on it to make sure it's done. So in the event that they miss their deadline, it's just can be approved and it falls on the shoulders of the private engineer, which the state statute allows. No harm, no fouls. It's all in place for that. So, you know, I'm super excited to hear them, you know, say that, because this enforcement action would be no big deal. They don't have it in their code. They have a goal out there that they've been blowing for years and years and years, you know, or, you know, the other part that's in, you know, is every application, they talked a lot about things that aren't even relevant today. And so I'll do the same. It'll be fun. Is every application for housing and every application that I've turned in has been opposed and had a recommendation for denial. And that's why every single one of those has been elevated to a hearings officer. And many of the times I've just asked for it to be elevated to a hearings officer because I had no faith in the city's ability to give a decision based on clear and objective standards. So I've asked for it. And to be fair, Mr. Collins has elevated some as soon as I've turned him in as well, because he knows that who I am and what I'm going to go do and what me and Mr. Kobach, you know, demand of the system. But every one of them they are 0 and 7. They've opposed it 7 times, and an independent hearings officer has given a decision of approval on 7 out of 7 over the last 3 or 4 years. That's what they don't talk about. Yeah, they're all approved. Okay, that doesn't mean that the state statute that we're talking about of undue costs and delays aren't occurring. They talk about the UIC on that thing, and they say, okay, yeah, well, it got approved. It's all good. It's, you know, no big deal. Well, guess what? I had to go over and I had to get my attorney involved in it. The delay that it was over on our side for the engineering was because their engineer gave us comments back about the UIC that was clearly approved in our land use approval, and we had to go fight with it with Mr. Kobach and get Ian involved to go tell him to accept it. That's what that was over on our timetable, was us fighting with the city to get that approved. On the same token, the exact same type of thing happened over with the right-of-way dedication. Ian goes and talks about, okay, hey, yeah, we accepted that dedication. I don't know what's his big deal. You know what we had to do? We had to go put in a writ of mandamus to force him to accept it, because we gave it to him and they sat on it. And sat on it and sat on it until we finally threatened them and we actually filed a writ of mandamus. Then they accepted it. Their comments are so skewed, it's embarrassing if you had the full truth of everything that I've gone through. I better stop or I'll start crying.
All right,
Go back, take it over.
I'm going to go through just kind of the punch list kind of, and like rebuttal, you're taking notes, and I wasn't able to take verbatim notes of what the city attorney and the city official said. So I'm going off of cryptic notes and a recollection, but I'll go back to what you tell a jury is I'm going to tell you what I think I heard, but you rely on what you heard, Hearings Officer Davis, because you're probably taking better notes than I was. But I'll try to not misstate anything. I want to start out by talking a little bit about the statistics on the number of land use applications that have been approved for housing units, and that's good. I hope more housing is approved, and you know, I hope people don't have the same frustration and troubles that Mr. Kind has had with staff opposition. to needed housing applications. But the focus of our issues are not really on those again. So I want to go back where we're demonstrating the delays is in the implementation of the conditions. That we can't get lost in the fact that we've got a lot of land use approvals that are going through. What happens after that to satisfy those conditions is really, really critical, because you could have 1 million housing units approved, but you got to get them built and approved. And the statistic I'd like to see, and I'm not accusing the city of burying it, maybe they don't have it, but it'd be interesting to see how much time it takes from the approval of a housing application to when the first certificate of occupancy is issued. You know, because really, I think when you're looking at people that need to get in housing that they can afford, that to me is kind of the critical time period. Is once the land use approval is done, how long do we have to wait before somebody can actually put their furniture in that house and have their kids go up to their bedroom and get all excited and do that stuff? That's a statistic that I would love to have heard from the city. So now the list of issues on that I want to respond to is not too exhaustive. Mr. Kine already hit on one, which is expiration, a little bit. And I agree. None of ours expired, and the statistics the city give you on expiration are probably true. But expiration really skirts the issue. What we've demonstrated in this proceeding with our evidence is when you get close to expiring on some of these due to these delays, the response has been that the city makes a process available to give more time, which is good in a way. But in a way, it's bad, because one, like for example, on Daily, when Mr. Stevens sent us the email in March saying, yours have expired, but here's a path forward. You can file 4 modification applications. Well, under the code, that's 25% of the base application fee. And I think Mr. Stevens will know the exact number, but I thought that each modification application cost $11,000. And so, well, that was kind of a mixed bag there. We got an opportunity to get more time. It cost us. And then again, more time really isn't the issue. And this dovetails with the next comment that the city attorney mentioned is the answer under 197-307 and 197-320 is the answer for the commission, you to recommend, and the commission to require the city to give more time, extend these, change these special conditions of approval to give applicants more time to do what's required to get these housing units occupied. We're going backwards if we're even going to talk about that, because what we're here to talk about is there's too much time now. We don't need more time. What we need is review periods and review processes in that time period we have that will allow those units to be built within the original time period. It would be great if in the city of Bend and other cities, we could live with expiration provisions less than 2 years and less than 3 years. If the norm was you never need 2 years because we're going to get this thing approved after your land use approval, we'll get all the drawings done, we'll get the infrastructure in, and we'll get people in those houses, and we don't have to worry about 2 years. That would be a great situation. So adding time is kind of just taking a huge step backwards in what we think we're trying to accomplish here. I do agree with Mr. Lighthizer that we're not asking you to tell the city from a policy standpoint, here's how you got to staff your people, here's how you got to make your administrative decisions for personnel, et cetera, and the number of hours they work. That is getting into the weeds. What I thought I was very clear about was, I think the answer is, if you give them deadlines, those issues work themselves out. Then the city has its discretion to do what it needs to do to get that time period met. And like the Kevin Costner, if you build it, they'll come. If you tell them they have to have it done, they'll figure out how to get it done, just like these other cities. And I do think that the city maybe went a little too far in criticizing the emails from the other jurisdictions, because what we were trying to demonstrate there is that the average time that these other jurisdictions have to get this process done is shorter than Bend's. And so all we were trying to show is there is another world. There is a world where jurisdictions figure out how to get it done. And in these neighboring jurisdictions, they have done it. And we're not saying that Bend has to do everything everybody else does exactly how they do it. But what we're trying to demonstrate is because other people have done it, there is a way to do it. And again, giving them a deadline will get it done. Mr. Kind took my thunder on the dedication. We did prepare a dedication deed. And what happened there is in batch review, we got a condition of approval that was a little bit unique in that it allowed us to dedicate the right of way before the final plat on just one of them. And so when I wrote this dedication deed, I followed the dedication deed from the earlier development down the street, and it did, and there was a delay, and we lost patience after a couple months, and so I had to file a writ of mandamus to get the city to record that deed, and that was the whether they would have recorded it or not, I don't know. I'm not going to tell you they wouldn't have recorded it, but the fact is they weren't recording it. And we had to file a writ of mandamus, and then they filed it. So it wasn't as if they just said, "Oh, give us the deed," and the next day they recorded it. That was a delay.
And so that was done. Was that done before this code got changed to allow this alternate track?
Let me think about that. The approval was, yes, the condition went in.
Okay, so that's what
before.
that goalpost issue is about.
Yeah, well, and I want to talk about the goalpost issue because I did have a conversation with Mr. Leikheiser. I think he characterized the discussion properly. We were talking about whether that provision could be applied to our applications, but staff was taking a different position, as I gave to you. Staff is taking the position, and they took it on a cappella, the one that my other client had to deal with, that even though the tentative approval vested and the goalpost rule does not allow the city to apply their new code to the tentative plan approval, in a cappella, the city applied it to the final plat approval because that's a separate application. And so the issue that I think remains unresolved, and if the city attorney's office wants to send me an email confirming that I'm right on this, I would like to see the city confirm in writing that provision will never be applied to our applications under a final plat approval application, because it is a separate application, and they have demonstrated in a cappella that their staff views themselves as having the ability to apply the new code to the final plat application, even though they know they can't do it under the goalpost rules to the tentative plan. So I think it's kind of an open issue. And
I think there's a case. I think there might be a case that's similar to that talks
Yes.
about when you've gotten something approved in the tentative
There is.
process. Yeah.
Sorry.
Well,
Yeah.
and since there's a case out there that says that, and we've demonstrated to you that city staff took the exact opposite position and forced an applicant in Bend to remove encumbrances as part of the final plat approval, I guess my suggestion is there's a disconnect. The city's not
Yeah.
following
Well, I don't.
the law.
What I'm saying is, I think there's a case out there. I'm not sure what the case holds.
Oh, okay.
I'll
Well,
have to
we'll
look it up.
it. It'll just give Mr. Leikheiser and me something to do, take up some more of our time. So that's what I have on that one. On the UIC thing, I think I think the information's been a little skewed. We did not complain about the land use approval. And when the city says, well, our decision was our decision, the hearings officer approved it, as Mr. Kind demonstrated, when you have a condition that allows you to do something, and then you submit your plans consistent with that to the city engineer, and the city engineer says, I don't care, I'm not approving your engineering because you have UICs. That was the problem. It was more on this back end where the city engineer was saying, well, I don't really care that the hearings officer said what he said. I'm not allowing you to do UIC. I'm not approving your plans. And so I did have to get involved, and I'm not going to say it didn't work out. Again, we got things worked out, but every time I have to get involved with the city attorney's office and staff, it is time and it is money that costs needed housing. And as Mr. Kine alluded to, we cannot bury our heads in the sand. When a project has added costs, and delay in development is cost, that goes into the housing units. We got to be realistic about it. You know, it's not free to develop. Developers have to pay to develop, so those costs have to come back. And so we're not doing much for needed housing, and if we're adding these costs and delays, even though we could say at the end, well, it all worked out. And then finally, I liked what I heard in the end about how the city is trying to make concerted efforts to shorten the review cycles. And I do have a suggestion for them. If they really can make meaningful progress on the first review, you know, say they could get the first review done in like 21 or days or so, like they do with affordable housing, and they had in their policies and code, etc., that all of the comments that engineering are going to make are on the first review, then I think we might be making some progress, because what we've demonstrated is oftentimes not only our applications, but other applications, our survey did this, is part of the problem is these new comments come on in the second and third wave that, you know, engineers are saying should have been on the first wave. So if we had all of the comments and they were required to do all of them in the first one, and they could not come back in the second and third with anything new, well, I think it would expedite the process, because then the private engineer, when they get it in their ball court, they have everything they know they have to respond to. And while there may be issues, there may be limited instances where this private engineer doesn't catch everything in their submission, I think it would substantially improve the review process, because in most cases, I think these professional engineers really take their job serious, and I think they would do a very good job of responding to all the city comments. So if the first review comments are limited solely to objective engineering, and there's no redesigning, and there's no personal preferences on there, it's just, do you meet the code or not? And they're limited to one shot on the first review, I think you'd see the statistics get better and better and better in support of needed housing. So, you know, I've said what I needed to say. I do want to let Mr. Kine, it is his petition. It impacts him on a daily basis and his ability to do what he does. So I do want to give him the last opportunity to say anything he hasn't said. And I'll close by just extending my appreciation to you, city officials, and Ms. Brewer and Mr. Howard for making this opportunity and this process available to us, because it is an important thing. We aren't going to agree on everything. We probably aren't going to agree on much, the parties anyway. But you all have given us a good process to do it in a constructive, civil way, and I'm really optimistic that at the end of this, something good is going to have to come out of this process. So thank you very much.
Okay, so before I turn to Mr. Kine, I do want to talk briefly about the timeline. So when we met last, when we had that pre-hearing conference, we talked about the timeline that I would have to issue my decision, and the required timeline for filing exceptions or objections to the proposed order. I think I have these dates. I think October 4th was the date that I would have to issue my decision by if the parties needed the full 15 days to object. But I kind of left it open that if the requester agreed to a shorter timeline for objecting, that would give me an extra week. So just putting it out there.
I remember that. And I think Ian had expressed an ability or a willingness to shorten the city's comment by a week.
But I didn't get confirmation from your side.
So let me just understand the date. So what we would be doing then is pushing back your decision from October 4th to October 11th.
Yeah.
And then we would have 7 or 8 days?
8 days.
8 days to object. You know, this process is just like drinking out of a fire hose anyway.
I mean,
so
the other option is
I think we could probably do that. I mean, I'm kind of getting used to, we were talking about this, Mr. Kine and I were talking about this the other day. We're kind of getting used to these short time limits, and we just get done what we have to get done. So if it's okay with the city to do that, we'll agree to do that.
Okay, and I will, I mean, I'm gonna try to get it done early. I'm gonna be gone that week of the 2nd anyway, so I might
Okay.
need to get it done early, but sooner I get it done, the more time you'll have.
Yeah,
Because I
no,
think
that's fine.
your deadline is a set deadline.
Yeah.
Because it's, okay, Mr. Kine.
Okay, hey, thank you very much, Chris. You did a great job. Thanks everybody else. You know, the one last thing that I think I wanted to get and is I think it's just I think you've got to be intuitive. You're talking about on the plans. The plans come in and they're not 100% complete compared to what the engineers think. But they turn in 50% completed plans or 75 or 80%. I mean, where is that sewage going to go? I mean, is it that the sewer line isn't connected somewhere? Is it the water line's not connected somewhere? Is it the street isn't connected somewhere? Is it the sidewalk? I mean, that's what we're talking about. Intuitively, engineers that have been trained for that the whole time aren't turning in partial construction drawings. They're turning in what they think is needed for the entire project. That is just such misleading, which is what happens time and time again with, you know, questions and answers and responses from the city. The engineers don't do that. Intuitively, you know, they don't do that. This isn't rocket science. We're not sending somebody to the moon. We're letting water flow to people's houses. We're checking fire flows, which is very simple calculations. We're having, normal drainage for sewer, for water, for absorption into the ground. This isn't rocket science. They're not turning in partial applications for the construction drawings. They're turning in what they think is the full construction drawings. The other part about it, and I think we turned that back in, Mr. Kovac, I hope you can confirm on that, but on where Mr. Stevens gave lists of all of these, responses and all these items that was on some of our projects. I mean, we could have easily gone and turned in all of our responses for all of ours or whatever. But if you go look at the ones that we turned back in, so you don't have so much work to do, you'll see we had the same comment 3 times. We addressed it, and they gave us the same comment without looking at it on those applications 3 times. I don't know what is going on over there in engineering, but that is as big of a problem as they claim that's happening over on our side. There is obvious evidence from what we've turned into the record today that that's happening at the city as well. And so, I think in leaving and finalizing, Mr. Kovac said it really good earlier. The system on the 120 days when you're going and doing a land use and you're having to go evaluate, all of the land use, be it traffic and engineering and access and infrastructure, that would be servant and the whole infrastructure of the whole city. If this new development can do that, somehow or another, that all gets done in 120 days. But now that we have that all done and we have a whole plan on that, it takes a year. Hello, McFly, somebody's got to realize that there's a problem there. That's just unrealistic, and so they didn't get anyone's done. Well, they collected more fees, and every single day that goes along on these housing projects with the value of land, with what's happened in the state of Oregon with wanting to concentrate land in urban areas has limited the supply of land to just this little area, which makes the land cost more expensive, right? So every one of these delays, when I have to go buy land and it costs me, it's thousands of dollars a day in interest, thousands of dollars a day, let alone the cost to hire Mr. Kovac, have my engineers, I used to be able to go and get a quote, 4, 5, 6 years ago in Bend. I would go down and I'd say, okay, I want to get a quote for what it costs to go do the engineering. And they'd come and they'd say, okay, it's $3,500 a lot, or it's $4,500 a lot. No one will do that anymore. That's a telltale sign right there in itself. Nobody will do that. We've got to do it time and material because it's so encumbering at the city of Bend. I can get that done in Redmond. I can get that done in Madras. I can get that done in Prineville. I can do that in Eugene. I can do that in Madras. I do that all over Boise. Can't do it in the city of Bend. that tells you something. Thank you so much. You've been very attentive, and I really appreciate, all of your efforts and having this arena to hopefully make, good changes for all of the folks. I mean, I'm spending my money to try to make it better for the whole thing. I'm at a place in my life where that's what I'm doing, and I'm taking my time, my energy, I'm taking the scrutiny of people throwing darts at me at the city of Bend, to try to make it better for everybody, because my kids live here and they can't even afford to live here anymore. And that's what's happening with all of my kids' friends and family. And that's why I got into the affordable housing arena. And we're one of the largest builders of affordable housing in the whole state right here in Bend. And it's frustrating when you can't get it through the system, on the backside. I know how to do it on the front side. Me and Mr. Kobach understand that. We get it done 7 for 7, with the opposing city. But when it comes on the backside, there's no accountability. And it's extremely frustrating when you're trying to go get housing for kids that grew up here in Bend to be able to live here in Bend and not have to move to Prineville or Madras or Lapine or somewhere else. It's very frustrating. Thank you.
Thank you. Thank you for your time. So I have one last question. I think during the hearing, I requested a copy of that Bend policy.
You should have it.
It was provided. I know it got sent to me. Did it also get sent to the city?
That was the instruction, but maybe.
Did you guys receive that?
I can check.
Okay.
Yeah.
I'd like
It
you to
would-
check that and just make sure that you received it and it's all what you would expect it to be.
I have an email from Mr. Kobach's office, which looks like a PDF of a January 10th, 2023 policy from the Community and Economic Development Department on expedited permit processing for affordable housing projects. So I haven't reviewed the document, but have the email.
Okay. Sounds good.
Is there an opportunity to provide any additional information on how engineering reviews work, if there's any interest in that?
No, there's interest, but it doesn't really fit within we already had final rebuttal, so I don't want to continue on.
Yeah, I recognize we could just keep going and.
Yeah.
I
feel like I got enough information. I'm sure there's always going to be more. So, okay, so it is 12:22 and we'll close the hearing and I'll get working on a written order. I do have some language here that was already, I think, stated by Mr. Howard at the beginning, that the order that I'm going to be submitting is a recommendation, and then the commission is going to be making the final order. So I'll just reiterate kind of what he said. So, okay, thank you.